Ooh, I almost forgot the microphone. Jamie would have a heart attack. I don't want Jamie to have a heart attack. Hey, everybody. Welcome back to the channel. I wasn't here on Friday. I just had one of those days at work where I couldn't come in time for the live stream. Had too much going on. But I'm glad to be back. Thank you very much for joining me tonight. We are actually going to be swinging back around to a case that we have covered. I think this would be the 11th time we have covered this case, though we haven't covered it nearly as much as other channels because I'm kind of allergic to crazy, weird drama. However, this case, it requires a look, okay? Now, we're talking about the murder of Boston PD officer, 46-year-old John O'Keefe. He died in the snow on January 29th, 2022. So we're 3 years past this. Now, prosecutors have alleged that it was his girlfriend, Karen Reed, 44-year-old at the time, Karen Reed. They were boyfriend, girlfriend. They were out with friends. I guess the part that's undisputed is they were out with friends. Everything else seems to be in dispute, right? So tonight we are going to be talking about the latest thing. You know, we're in the second trial is coming up. They're marching toward the beginning of the second trial. The first one, of course, ended in a mistrial, and there are strong feelings on both sides of this case. Strong feelings that Karen Reed is innocent, that she is being railroaded, that she is being set up, and strong feelings on the other side that no, she is not being railroaded, she's not being set up, she is being prosecuted properly. It just, the prosecution or the police just, they messed up in a lot of ways. I guess, I'm trying to be fair. That was probably pretty prejudicial, but I'm trying to be fair. Just, yeah, everybody feels a certain way about this case. Now, this week, before we really jump into it, guys, let me just tell you that in about 26 minutes, there will be not a live stream, a premiere going on over at Courtroom Confidential. That is an interview that I did a couple of days ago, actually. So pretty awesome that I'm on that. Unfortunately, my schedule is my schedule, so I won't be able to be there for most of the beginning of that premiere, but I did put a link to it down in the description below. I also shared it on X. Ashton shared it on Instagram and Facebook for me, so there are links everywhere. Okay, so check that out later. Okay, so what has happened this week in the case of the murder, the murder of John O'Keefe and the trial or case against Karen Reed is, as you guys know, as we march toward a trial, there is always a kind of dump of motions. Okay. And this trial is no different. There is definitely a bunch of motions that are going to be filed. There are going to be many of them. There will be oral arguments. There will be all sorts of rulings coming down in this case, but this is one that was just released. It is heavily redacted. We're going to yada yada a bunch of this. It's a 147-page motion by Karen Reed's side to dismiss the case with prejudice, meaning it would not be able to be brought in again. And the allegation is that the government has behaved badly, that they have done lots of things that warrant a dismissal. Now, in fairness, all these 147 pages, most of them are exhibits, right? So we don't have to worry about going through 147 pages today, but we're going to go through a lot of it. The Commonwealth of Massachusetts has responded in their own document, their response to Karen Reed's motion to dismiss because of misconduct. We're going to get into that a little bit too. Okay, these were, this one I believe was filed on the 28th of February. This was filed on the 21st of February. We're going to yada yada a lot of this. Don't worry, we're not going to be writing or reading 100 and what does that come out to be? 162 pages. That's not going to happen. I do want you guys to feel free to talk amongst yourselves over in the chat, but I do know that this case brings out certain feelings, so we want to make sure that we keep it nice and respectful. Now, if you want me to be able to see your comment, just please put GF in your comment, and that will help me to see it. And it looks like you guys, so far, you are not, you don't need me to see anything. All right, so let's go ahead and dive into this document. Here we go. Now comes the defendant, Ms. Reed, respectfully moving the Honorable Court, pursuant to Article 12 of the Massachusetts Declaration of Rights, yada, 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 to dismiss with prejudice all charges with prejudice on the basis of extraordinary governmental misconduct, yada, yada. Okay? A prosecutor, quote, may strike hard blows, but he is not at liberty to strike foul ones. It is much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. This is Berger v. U.S. Throughout the course of these proceedings, argues Ms. Reed's lawyers, Ms. Reed has been severely prejudiced by the Commonwealth's pervasive misconduct. By the way, if you believe that the Commonwealth has behaved with pervasive misconduct, I would love to hear your comments. As long as they are respectful, be sure to put GF in there so I can see it. Okay, like for example, here is Idea Delight says, I don't think there will be another trial. You are way too fair to prosecution. Once the crash daddies came to say John was not hit by the car and the car did not hit John, case closed. Yeah. So I am on the side that Karen Reed is being railroaded, but I am trying to remain as fair as I possibly can. I can't be impartial because that is the way I lean. But I am going to be as fair as I can to the process, because to me, guys, the most important thing in all of this is the fidelity of the law, right? So here's my argument. If a defendant like Karen Reed does exactly what the prosecution alleges, does with malice aforethought, take the life of another human being, and the prosecution through its own misconduct and purposeful and wanton behavior does not give or takes away the rights of the defendant, it is more important to me that guilty defendant go free than that defendant be convicted. I'm sorry if that's unpopular, but the fidelity of the law is just the most important thing. And I think that it's fair to say, I honestly feel that it's fair to say that the fidelity of the law, the law is not fidel in this case, right? It's not. So anyway, that's my soapbox. Let's head back over to their argument. Okay, the Commonwealth has suppressed discoverable and exculpatory video surveillance footage from the Canton Police Department, and they talk about this a little bit more. It has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started and after the Commonwealth represented that all video footage had been provided to the defense. That is a major problem, guys. It's a major problem. For reasons that remain unexplained, much of the video that has been disclosed is missing critical timeframes and evidence central to Ms. Reed's defense. Again, if there is stuff that is missing, then that goes to misconduct, right? You can't, remember in the Madeline Soto case where Chris Stearns was talking to Stefan, and Stefan had a flat tire, and then Madeline was missing, and then this, and then that, and then that. And Chris Stearns was like, wait a minute, there's too many things happening here. Red flags are going up. That's the way I feel in the Karen Reed case. there is human error. Police can make mistakes. They frequently do, just like I frequently do. Prosecution makes mistakes all the time. But when it becomes a pattern of mistake making, a pattern of withholding evidence and saying it was accidental, then yeah, I'm starting, the red flags are going, they're going up the flagpole, right? Okay. Some of the video clearly appears altered or manipulated, as evidenced by people appearing and disappearing out of nowhere. At the first trial in this matter, Assistant District Attorney Adam Lally, this was the Assistant District Attorney who prosecuted the case in the first trial, brazenly introduced inverted video and elicited patently false testimony from MSP Sergeant Yuri whatever, blah, 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 that the video was a fair and accurate depiction of critical events in an attempt to falsely insinuate to the jury that no member of law enforcement ever approached, touched, or otherwise disturbed the right rear tailgate of Ms. Reed's SUV. Again, now the prosecution claims, no, that is the way that the system recorded it. We didn't mess with it, but I call shenanigans on that one. It's a bunch of hooey. Those systems do not record things backwards or in reverse. Come on. If they do, then you've got a problem. So anyway, there can be no doubt that this video and false testimony was offered to mislead this court, the jury, and the defense by making it appear that MSP Trooper Michael Proctor, we all remember his name, was standing next to the left rear taillight when the Commonwealth knew the exact opposite was true. Trooper Proctor was in fact standing directly next to the right rear taillight. Other Sallyport video, which was unquestionably favorable to the defense because it would have severely discredited key witness Brian Higgins, redacted, inexplicably was not disclosed to the defense until months after the first trial. Guys, that is an issue. That is a big problem. Now, you guys understand what a Brady violation is, right? Of course you do, because you're awesome and you follow true crime. But here is the thing. The Brady law basically makes it illegal to withhold exculpatory evidence. I should say willingly or knowingly withholding exculpatory evidence. So if there is a Brady law violation and it is just giant, to me, that is enough. That is enough, because we live in a world of incentives and disincentives, and prosecutors who are all people that, I mean, I have no problem with the career of being a prosecutor. I'm deeply grateful for it. So the opposite is true. I'm deeply grateful for it. But their incentive is to win. Their incentive is not to get justice. Their incentive is to win. Likewise, with defense counsel, their job is to win. But there's a problem on the prosecutorial side, because we all believe that their incentive is to seek after justice, but the incentives are not there for that. No prosecutor gets reelected by seeking justice by kicking cases. They are judged by how many wins they have, and that's just the way it is. So for me, because that incentive structure is there, if a prosecutor conducts him or herself illegally by breaking the Brady law, by having these Brady violations, that is enough for me to kick the case. And if I were a judge, that would be it for me. That would be it. Gone. So, and they could say, but Your Honor, we didn't know about this. To me, it doesn't matter. You should have known about it. And, you are team members with the police. The police knew about it. Come on. Okay. Uh, the Commonwealth exploited this court's order instructing the defense to disclose its impeachment material in advance of witness testifying. ADA Lally and MSP Lieutenant Brian Tully huddled with key witness Jennifer McCabe mid-trial, prepped her on how to explain why she never disclosed that she went to CPD Sergeant Michael Lank's home one day after John O'Keefe's death, and then suppressed exculpatory statements made by McCabe during that session until nearly a month after McCabe's testimony, at which point McCabe and other relevant witnesses were safely off the witness stand. If the Commonwealth had complied with their obligation to provide statements of witnesses before they testify, the defense would have been positioned to expose McCabe's material, inconsistent statements about her meeting with Sergeant Lank. As a result of this extraordinary governmental misconduct, Ms. Reed has been permanently and irreversibly denied her constitutional right to a fair trial. No remedy other than dismissal can adequately address the significant harm caused to Ms. Reed and the injustice of proceeding without the lost exculpatory evidence that was in the Commonwealth's possession, and then it redacts probably the list of that exculpatory evidence. Accordingly, the case against Ms. Reed must be dismissed with prejudice. And by the way, if the police did and the prosecution did as the defense is alleging here, and remember, this is only an allegation. This is not fact. Well, it might be fact, but we can't take it as fact. We have to take it as an allegation. But if the prosecution and the police did behave the way it is alleged in this, that is enough for me. Even if Karen Reed did indeed kill John O'Keefe. Okay. Let me yada yada the statement of facts. We all know what's going on. Let's see. Let's go here. Facts relating to the destruction and withholding of exculpatory Canton Police Department video surveillance footage. The court is aware of the critical importance of the video surveillance footage from the CPD on January 29th. The Commonwealth has produced dribs and drabs of various clips of video surveillance obtained from the CPD's ExactQ Vision DVR system from January 29th, without any accompanying reports, evidence logs, or other documentation regarding the recovery and chain of custody of this evidence on at least 4 separate occasions. Guys, that is an issue if it is true. And then relevant discovery orders. Okay, we're going to go through there. Dates of production of and facts relating to discovery and constitutional violations. And then this is mostly redacted. Notwithstanding this court's October 5th, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, that metadata is important, by the way, the Commonwealth and its agents withheld exculpatory evidence from the defense for more than 2 years, failing to disclose even the first incomplete batch of the footage until the eve of the first trial on April 4th, 2024. The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage recorded at the CPD January 29th. Okay, April 4th production, we'll go through that. April 10th, they filed a certificate of compliance. Okay, got that. April 23rd, the Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear tail light of Ms. Reed's SUV. That is, I mean, watching the trial, I think that is true. I think defraud is a prejudicial word, but I still think it's true. On April 23rd, the Commonwealth produced additional footage from the CPD Sallyport back wall via ShareLink, titled, he put entitled, but it's not entitled. It's titled, Additional Sallyport Video Download Link. No flash drive was presented to the witness. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury that nobody approached or touched the right rear tail light of Ms. Reed's vehicle after it entered the Sallyport. ADA Lally craftily elicited testimony From Sergeant, I can never remember his name, that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV when it arrived at the CPD on January 29th, and that, as seen in the video, no law enforcement officer approached the right rear tail light. On cross-examination, however, the sergeant's testimony was exposed as profoundly misleading at best and perjurious at worst. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality. Critical facts which neither ADA Lally nor the sergeant saw fit to inform the court. In other words, this video made the left side of Ms. Reed's SUV appear to be the right, and the right appear to be the left. Okay, we got it. Lots of yada yadas there. Okay, October 10th. They are alleging a Brady violation. The Commonwealth produces additional exculpatory video surveillance footage in violation of Brady and Rule 14. So post-trial on October 10th, 2024, the Commonwealth again provided new footage, this time from the CPD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side cameras. This footage shows Higgins arrive in the parking lot of the CPD at 1:26 a.m., enter the building, and speak to some unidentified individuals on the phone as he is leaving the CPD at 1:34 a.m. Significantly, this specifically requested material and relevant evidence which establishes that Higgins was on the phone with some unidentified person at 1:34 a.m. as he left the CPD shortly after O'Keefe's death was suppressed until after the first trial. Here's another Brady violation, they're saying. November 8th of last year, while preparing for Ms. Reed's second trial and in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, attorney Elizabeth Little emailed Special District Attorney Hank Brennan. I think this is the new guy who is prosecuting the case. Mr. Brennan, again requesting all raw video footage from the CPD, which shall include but is not limited to all cameras capturing the exterior of the CPD and or the exterior of the CPD, including all parking areas, entrance and exits, and garages between the 29th at 12 a.m. and the 29th at 11:59 p.m. On November 25th, 2024, ADA Brennan indicated via email that he would request that CPD provide all requested footage. Ultimately, the defense requested access to the CPD DVR system and drives that hold recordings from the security camera system so that defense expert Matthew Erickson could obtain video files and corresponding log files from those times. Upon reaching an agreement with the Commonwealth, Erickson visited the CPD on the morning of December 12th, 2024 to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days, which means that the Commonwealth failed to preserve the specifically requested material and exculpatory footage relevant to Ms. Reed's case via standard forensic protocols, as they were obligated to do pursuant to February 2, 2022, Preservation Order, and October 5th, 2022, Order compelling discovery of all videos and related metadata. If that was done on accident, I don't see how that was done on accident. I honestly don't. Like, these DVR systems have export files that export basically a Microsoft executable file that opens up a media player, and it has all the little windows and you can click on the windows. It's very difficult actually to export from those DVR systems the raw footage, but it's possible. I mean, it's difficult for somebody who doesn't know how to do it. They should have had that all exported instead of exporting piecemeal those executable files. That is bullcrap. Let's pause for a second. Let's head on over to your comments real quick. Where am I going on my side? Give me a second. Having issues. Okay. See what you guys have to say. See if there are any. Need some Z's. Gavin. The Commonwealth still hasn't given all video surveillance from the Sallyport or any metadata. You're right. And that metadata is super important, guys. I don't know. I want to bring up the victim on this because I think I think it gets lost that we've got a victim who's lost his life. Whether it was done by Karen Reed or somebody else, he is the victim. So I like to bring that up. And yeah, the metadata is super important as well. That's one of the things that I've complained about on the Ellen Greenberg case. So the Greenbergs, through their attorney, shared with me the images that were supposedly taken by the medical examiner's office and the medical examiner's investigator, both at the scene and at the autopsy, and none of those files include any metadata, which tells me they probably have more photos that they just don't want to give. Where are the originals? Where are the ones that have all the metadata? I want to know which pictures are missing. And that's why the metadata is super important to the case here. Christine says she likes my hat. Listen, Christine, thank you, first off. Second, I have super long hair right now for me, not for other people, but this is as long as my hair has ever been. I'm trying to grow it out to donate my hair. I don't know if anybody's going to want like a middle-aged guy's hair, but anyway, I want to be able to grow it out to donate it. It is driving me crazy. It has been under a hat today because I was out in the field reporting and I wanted to do my hair for the show. I couldn't get it to even look remotely good, so I stuck on a hat. That's what I did. Thank you very much. Let's see what else we got. Missy says, I feel a prosecutor should bring charges against in order to seek justice, then win the case. The moral compass is at the charging time. Yeah. So, I mean, in theory, that's the way it should be. The problem is in the metrics of what is a successful prosecutor. That's the problem. So when a metric becomes a goal, it ceases to have value as the metric that it once was. And as soon as prosecutors started going, hey, I have won 192 cases in my career, including 67 homicides, and I've never lost a case, blah, 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 then that's their goal. And that's the incentive. So, yeah, prosecutors should act that way. In fact, I would say that prosecutors most of the time do act that way. Yeah, I mean, I know prosecutors and have for a long, long time. And I hold, all of the ones that I know in really high regard. But the incentive structure is still there. So whether they are a good person and have integrity or not, well, I've just incepted myself. Give me a second. The premiere is starting over there on. Sorry about that, guys. On Courtroom Confidential. Anyway, the incentive is still there, and therefore it is going to cause the people that it impacts to behave differently than what the ideal is. That's just the human experience. That's the way it is. Great comment. Phoenix goes, Gavin, off subject. Did you donate your hair over the weekend? No. It's still there. It's just really like down because I was wearing a hat all day. Idea Delights, you're welcome. Glad to do that. Robin Bernardi says, you're stealing my shenanigans go-to word. I like the word shenanigans. I like it. Robin says, perhaps the pattern is their police is consistently inept. I mean, perhaps that's not any better than what everybody else thinks. That's really funny. Thanks, Robin. Great comment. Let's see. Lindsay still likes my hat. Great. Bad hair day. Yes, indeed. Yes, Brie. I'm trying, guys. It's driving me crazy, though. I really don't like it. Okay. Let's get back to the case. Here we go. Over here, pushing the right buttons. Okay, so January 28th, 2025, just a little over a month ago, the Commonwealth, according to this allegation, produces more exculpatory blurry video footage surveillance footage establishing that an unidentified person approaches the right rear taillight of the SUV as soon as it enters the Sallyport garage. Okay, so on January 28th, 2025, the Commonwealth yet again turned over additional CPD surveillance footage from January 29th, 2022, this time from an exterior camera depicting Ms. Reed's SUV being brought into the Sallyport garage. Blah, blah, blah. Okay. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Ms. Reed's SUV immediately after the vehicle is brought into the Sallyport garage, and then exit shortly thereafter. If this video were not blurred out, the surveillance feed would have captured yet another angle of the right rear taillight as it entered the Sallyport garage. At a certain point, this is a great argument. At a certain point, it defies logic that all CPD video surveillance footage coincidentally cuts out, blurs out, or becomes grainy at the precise time the right rear taillight of the Lexus SUV should be in frame upon its arrival at the Sallyport. This angle of video surveillance is exculpatory and was withheld from the defense prior to the first trial. Okay, listen, I gotta have an Uncle Gavin moment here, okay? Uncle Gavin moment. Dear Canton PD and all police departments around the nation. A modern 4K to 8K video surveillance system is dirt cheap. Please find somebody in your organization to write a grant and get yourselves some good surveillance video. It's not hard. It's not hard, okay? And it's cheap. I mean, the level of quality that I get out of the video surveillance at my home is impressive and impeccable, and it does lighting really, really well. It does darkness really, really well. Please, for the love of all that is holy, please go get some good cameras, okay? And you know, while I am on this soapbox, because this drives me crazy, let me talk to county jails for a moment, okay? Listen, when you process somebody and you take their mug, okay? Back in the day, when they took mug shots, they were typically using a medium format camera. Later on, it was a 35 millimeter camera. But you know, those 35 millimeter cameras or the 6x4s or the 4x4s, 4x5s, those things did super high resolution. And y'all, when you went to digital cameras in 1996, have this super low, grainy, terrible resolution. And I mean, you could spend $49 on a new camera and get a good resolution photo. Okay? Please do that. As the guy who does all the criminal reporting in my area, I would love a mugshot that is bigger than half a postage stamp, please. Okay, all right, I'm off my soapbox. Sorry about that, guys. All right. I feel like I want to yada yada McCabe, but maybe not. Okay. McCabe is a key Commonwealth witness. Her credibility is critical to the Commonwealth's case. On February 2nd, 2022, mere days after O'Keefe's death, the MSP obtained and forensically imaged McCabe's cell phone. Yeah, I mean, I get all this, how long to die in the cold and all that fun stuff. Okay, I'm going to yada yada that because we have gone over and over and over that. So I'm going to yada yada. Okay? Argument part 2. The Commonwealth has engaged in numerous Rule 14 discovery violations and constitutional violations under Brady v. Maryland and its progeny. What that means is that Brady v. Maryland is a case that made it to the Supreme Court and established the rules of discovery of exculpatory evidence, okay? Its progeny, what they're talking about, are case files that have and rulings that have come because of Brady. So yeah, it's not terribly confusing legal doctrine, but the way they write it is just so dumb. Okay. Ms. Reed's constitutional rights to effective assistance of counsel and due process under the law is guaranteed by the 12th Article of the Massachusetts Declaration of Rights and the 6th and 14th Amendments of the U.S. Constitution require that the Commonwealth disclose certain evidence in advance of trial. Blah, 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 yada, yada. Blah, blah, blah. Okay, pursuant to Brady v. Maryland and its progeny, defense counsel is entitled, as a matter of due process, to all evidence that is favorable to the accused and material either to guilt or to punishment, including impeachment evidence and evidence necessary to place the witness in his proper setting and put the weight of his testimony and his credibility to the test. Brady disclosure also extends to disclosure of information useful to the defense to attack the reliability of the police investigation and the police methods employed in assembling the case. Kyles v. Whitley, which would be one of the progeny cases, Lindsay v. King. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts rules of criminal procedure clearly state that the Commonwealth must provide certain mandatory and automatic discovery of the evidence within the possession, custody, and control of the Commonwealth to the defense in order to meet its mandatory discovery obligations. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, tangible objects, and all intended exhibits, reports of physical examinations of any person or of scientific tests or experiments, and statements of blah, blah, blah. Okay, lots of yada yadas. Okay, the rules also state that the defendant may move for discovery of other material and relevant evidence not required by that part of the criminal procedure. Here on February 2, 2022, the Commonwealth was ordered to preserve all physical evidence, including video surveillance footage in Stoughton District Court. Subsequently, on October 5th, this court ordered the Commonwealth to produce all videos in connection with the case and associated metadata. Notably, this prosecutorial duty to produce evidence covered by Rule 14 extends beyond just the prosecutor to all agents of the Commonwealth, including police. Bunch of yada yadas. Okay. As set forth herein, the Commonwealth has repeatedly violated its discovery obligations under Brady v. Maryland and its progeny. By the way, if they were to win this motion and it was ruled that there were Brady violations, that is reason for sanctions against the prosecution. And they should be harsh sanctions because Brady is that important. It's just we want every defendant to have a good, competent defense. I mean, everything hinges on it. Otherwise, all defendants could be railroaded, including all of the innocent ones. So, yeah, if this motion prevails, and there are problems with it, but if this motion prevails and they're found to have Brady violations, I hope that sanctions are brought. I hope they're brought to the prosecution. I also hope they're brought to the police. And they should be. Okay, and then it talks about, all the ways that it did that. We're going to yada yada. We know we know all the background. Blah, blah, blah. Withheld exculpatory statements by McCabe. Yes. Okay. So the Commonwealth's egregious and repeated discovery and Brady violations required dismissal of this case with prejudice. With prejudice, of course, means you cannot bring it ever again. When the Commonwealth fails to comply with its discovery obligations, the court has the ability to impose remedial sanctions. Get through the yada yadas. Okay, dismissal is appropriate as a remedial sanction as a way to cure any prejudice caused by the violation of a discovery obligation and ensure a fair trial. A couple of yada yadas. The Supreme Judicial Court has identified two parallel legal principles governing when dismissal might be necessary, balancing the right of defendants against the necessity for preserving society's interest in the administration of justice. And then they make the case law argument. I'm going to yada that. Dismissal is the only appropriate remedy for the Commonwealth's egregious and repeated noncompliance with its discovery and obligations. Then it makes its argument for that. And then I think there's a second one. Yeah, and this is all stuff that we know from before, but it's a long argument, and it's a good argument. And then dismissal is the only appropriate remedy for the violation of Ms. Reed's Sixth Amendment right to trial by an impartial jury. And then bunch of redacted stuff. Okay. Yeah, I'm gonna yada yada that, guys. Conclusion. Okay, for the above reasons, Ms. Reed respectfully requests that this honorable court grant defendant's motion to dismiss for extraordinary governmental misconduct with prejudice. Although dismissal is required and appropriate under the circumstances, in the alternative, this is something that always happens in legal or in motions. Like, this is what we're asking for, but alternately, if you don't like what we're saying, you could do this too. So in the alternative, the defense seeks and is entitled to an evidentiary hearing on these issues attendant to the Brady violations and juror interference. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ADA McLaughlin, ADA Brennan, Lieutenant Tully, Chief Rafferty, Trooper Proctor, Sergeant, I can't remember his name, Colleen Crawford, and other members of the CPD, and Lieutenant Fanning. And that is their motion. Okay. I know I yada yada a lot. By the way, you can go over to my Patreon account. I've put both of these documents. If you're a supporter of mine on Patreon, both those documents are there. You can read them in your entirety. Okay. Let's head on over to your comments here. All right. Let me get this refreshed. The judge did dismiss the case against Baldwin because of a Brady violation by the prosecution. Yeah, that's exactly what happened. Alec Baldwin was not actually put on trial. He did not make it all the way to trial. He did not have to defend his actions or inactions, or his negligence or whatever, because the prosecution withheld exculpatory evidence. And that's how we got off, with prejudice. So great, nifty 50-50. That is a great comment. Good job. Let's see. Hey, Bree, thanks for gifting that membership. Appreciate that. Holy cow. 5 more. Holy cow, Bree. Thank you very much for gifting all those. Hope you guys enjoy those memberships. Robin says that she should tell me that I recommend giving up and going for a messy bun. Yeah, it's not long enough quite yet. Okay. All right. Let me real quick head over to, let's hide this. I want to show you, because it wouldn't be cool if I'm only showing what the defense is alleging. Let's see what the prosecution says in their answer. I'm going to yada yada a fair bit of this too, okay? But this is their answer. Now comes the Commonwealth, and the above captioned matter submits the following opposition. Dismissal is a sanctioned, very strong medicine, and it should be prescribed only when the government misconduct is so intentional and so egregious, and appropriately only upon a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. You know what it seems like their argument starts out with? Yeah, we are behaving badly. Our conduct has been horrible, but it's not bad enough for a dismissal. That's what it seems like the argument is. Okay? To the extent the defendant has suggested that egregious circumstances might warrant dismissal, the Supreme Judicial Court has noted that we have never dismissed charges in such circumstances in the absence of prejudice. Judicial responses should be limited to truly remedial and not punitive measures. So they're like, this is what their argument seems to be. Yeah, we did do all these things that they're saying we did, but it's not enough to dismiss the case. The sanctions should be lighter. The Commonwealth does not dispute its prosecutorial obligations and constitutional duty to disclose in a timely manner material exculpatory evidence over which it has possession, custody, or control. That's Brady v. Maryland. Nor does the Commonwealth dispute its broad obligations to inquire and disclose any facts that would tend to exculpate the defendant or diminish her culpability in all statements of witnesses. However, to prevail on a claim that the prosecution failed to disclose exculpatory evidence, the defendant must prove that the evidence was in fact exculpatory. That's hilarious, because I think their argument was this is exculpatory, and I thought it was a strong argument. Exculpatory evidence includes all evidence that tends to negate the guilt of the defendant or provide some significant aid to the defendant's case. And while rightfully broad, the conception of exculpatory evidence is not boundless. Let's talk about the surveillance video. In 2022, the Commonwealth provided the defense with approximately 90 crime scene services photographs depicting the condition of the defendant's vehicle in the Canton Police Department's Sallyport. Further provided to the defense was ring surveillance video of the defendant's broken rear right taillight at approximately 5 a.m., statements of witnesses who observed the defendant's broken taillight around 5:30 a.m., Canton Police Cruiser video depicting the defendant's broken taillight at approximately 8 a.m., observations of a damaged taillight by the Dighton Police, and automated vehicle location data from troopers cruisers who were assigned to the CERT team, evidencing that the CERT team was on Fairview Road before the defendant's vehicle arrived at the Canton Police Station. Lieutenant Kevin O'Hara, this is the argument that they did through the whole time. So I'm going to yada yada. Okay. Beyond unsupported claims and vague innuendos, the defense struggles to establish how the condition of the defendant's broken taillight in the Canton Police Department Sallyport is in fact exculpatory or the most critical and highly contested issue in the case. Defendant motion at 7. Okay, despite claims to the contrary, the defense never filed a motion to preserve, or in its perpetually evolving theory of the case, did the defendant specifically request, prior to November 2024, surveillance video from the Canton Police Station. That's pretty crappy. They never requested it. We had it, but they never requested it. And the defense is going, yeah, you had it, and it's exculpatory. It's a Brady violation. You should have given it to us. Nevertheless, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor. Prior to that, the prosecutor had not been alerted to its existence by investigating officers. And again, the officers are the agents of the state as well. So it doesn't matter that the prosecutor didn't know. The police were hiding it. Okay, I'm going to yada yada all this. The Commonwealth filed its certificate of compliance on April 10th, noting that to the best of its knowledge and after reasonable inquiry, it had disclosed all information subject to the criminal procedure. The parties were in court on the 12th to argue motions in limine. During the defense's televised motion to admit third-party culprit evidence, Attorney Iannetti made representations about the Canton Police Department's surveillance videos. Following the hearing on April 17th, Lieutenant Tully sent prosecution team members an email stating, "I spoke with Chief Rafferty. She reviewed the video of the SUV arriving at CPD exists, and we should have it, contrary to what the defense represented on Friday." Okay, so the defense is saying that the video doesn't exist, and they're like, "Oh, no, we have it." So I'm going to yada yada most of that. After the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office reviewed the surveillance footage that had been previously produced to the defense, recognizing that the video was extremely dark with minimal visible detail. The video technician clarified the video footage on October 10th. The Commonwealth produced to the defense clarified videos, reports detailing the forensic clarification process, associated hash values, and extracted still images from the Canton Police Sally port. You know what, though? They just needed to produce the raw stuff with the metadata. Like, we did all this for you. We clarified it for you. We lightened it up. We gave you some stills. Like, no. We want the raw footage. We will do all of those things. So, anyway, after trial, the Canton PD provided the Commonwealth with 2 additional videos. Again, that should have been already provided. The defense boldly claims that the surveillance video of Mr. Brian Higgins in and outside the Canton Police Station proves that he perjured himself before a federal grand jury. This claim is extremely prejudicial and false. In support of this claim, the defense cites the federal grand jury transcript and then it's redacted. So that seems like a valid argument. Excuse me. Yeah, both Higgins and Albert were thoroughly cross-examined about their phone calls. Yada, yada. It does seem to me, though, that they are arguing, I don't want to go too long here, guys, that they're arguing that they did misbehave. Their conduct was misconduct. But they did their best, and yeah, there's some mistakes here and there, but it doesn't warrant a full dismissal. I'm just going to kind of yada yada down here. Even if this court were to engage in a balancing test, dismissal would be inappropriate as there's no evidence of egregious misconduct on the part of the Commonwealth, and any potential prejudice stemming from the overwritten videos would be remedied at trial. Okay? The defendant can point to no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video to fully disprove the defense's repeated and baseless allegations of evidence tampering. That's rich. That is a cute argument. Hey, we wish we had it too. Therefore, we have no bad faith. That's pretty cute. I'm going to yada yada Jennifer McCabe. Yeah, I think this is fun. The court, security, juror dismissal. Yeah, okay. Going to yada that a little bit. And I think that might be okay, let's see the conclusion. In sum, the defense motion should be denied. The defendant can show no irremediable prejudice to her right to a fair trial, nor has the evidence in good faith shown that the Commonwealth engaged in prosecutorial misconduct. Though it does seem like they admitted to it. I'm sorry. Dismissal of this case is accordingly not appropriate. Further, where the defense's claims do not raise any substantial issues, the request for an evidentiary hearing should also be denied. And that is from Mr. Brennan. Okay. So let's see if you guys have any more comments here before we call it a night. To me, it's a pretty weak argument, pretty weak sauce. Let's see if there's anything. Just going to try to go through this. Hey, Jojo Fosho, thank you very much for gifting those memberships. Appreciate that. See if anybody else is there. Mooney's a lurker. Okay, we're good. Thanks for all of you that gifted memberships to the channel. I deeply appreciate that. Hey, remember that these documents in their entirety, 147 pages of one, 15 pages of the other, are available to my patrons who take very, very good care of me, for which I am deeply grateful. Now I'm going to quickly head on over to Courtroom Confidential to engage in that live chat. I hope you will join me over there. The link is below. Before we go, just a quick reminder that you can sign up for Crime Cod's newsletter. If you go to my website, you'll see on the front page there are a bunch of true crime cases or articles. You click on them, that will take you over to Crime Cod, and you can sign up for the newsletter there at Crime Cod. It's our daily true crime newsletter. Also, you can find me on Facebook at The Fish Tank. So if you are on Facebook, you like that kind of deal, please join me over there. With that, guys, thank you very much for being here. I bid you adieu, and I will see you tomorrow. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.